Hey guys, it's Jenny Silver, and today I want to talk to those of you who need to file an appeal with the California EDD. Many of you have been asking questions recently regarding filing an appeal with California EDD due to recent disqualifications, letters of determinations, and overpayments. An appeal with the EDD means that you are contesting any decision that the EDD has put forth on your account. Any decision made by the EDD is appealable, so this process is going to be applicable if you are contesting anything along the lines of an overpayment, a disqualification of benefits, or other such similar decisions. I'm going to walk you through the process of how to file the appeal, what happens before, during, and after the appeals process, how you can appeal the appeals decision, and some additional information. First, this video is sponsored by Pershing Square Law Firm. Pershing Square Law Firm is California's first and only law firm dedicated to EDD law. They represent clients in appealing any kind of adverse decision made by the EDD. Whether it is a denial of benefits, overpayments, procedural, or computational issues with your claim, they represent claimants undergoing any of these issues. In the 8 years they have been in business, they have maintained an A+ rating and accreditation from the Better Business Bureau. They offer a flat rate fee and do not operate on percentages, so claimants keep almost all of their benefits. Pershing Square Law Firm understands that their clients are undergoing financial hardship, and therefore their pricing is intended to be very accessible to most people, even those undergoing such financial hardship. Lastly, they offer a complimentary consultation, and anyone facing legal issues with the EDD can call into Pershing Square Law Firm and receive helpful information and get questions answered directly from an attorney through a free consultation. Click on the link in the video description in order to contact Pershing Square Law Firm. California EDD will send you a notice of determination letting you know that you have been disqualified for your benefits or that you have been overpaid by your benefits, with information regarding how to appeal, why you have had your benefits disqualified, and some personalized information about your own unique claim. Also included with that notice of determination is going to be an appeal form, which looks like this. In order to contest the decision that has been made by California EDD, you will need to complete this form and file the appeal with California EDD within 30 days of the EDD mailing this notice to you. Unfortunately, many may have missed the 30-day deadline in which you must have filed the appeal by and are wondering if you can file this late. The EDD states that if the appeal is being filed late, it should also contain an explanation as to why it is late. If there is good cause as to why it was filed late, then it may possibly still be accepted. The appeal form must be filed in writing with the office location listed on your EDD Notice of Determination. Refer back to your Notice of Determination and locate the specific office name and address, and that will be the location where you mail your appeal form. Once the EDD has received your appeal form, then they are going to forward the request and information over to the California Unemployment Insurance Appeals Board. This is a completely separate organization and is not controlled by or within the EDD. Once the appeals board receives it, they then process the appeal and schedule a hearing. There are 11 appeals board field offices located around the state. At least 10 days prior to the hearing, you will be mailed a written notice that includes the date, time, and location of your hearing. Now, unfortunately, in most cases, they state that you cannot change the date or time, but they do state that you do need to call into the Office of Appeals to make your request. The phone number in order to do so is listed on your notice of hearing. If you do not call before the hearing in order to request a change of date and time, your failure to call may be counted against you later by the judge. The appeals board states that you should bring witnesses to the hearing if it helps to support your case. They state that eyewitnesses are best, and the judge will decide which witnesses will be allowed to testify. If a witness cannot appear in person, you may request to have that witness testify by phone. You will need to give good reason for the request. Call the Office of Appeals on the phone number listed on your notice of hearing to make that request. Next, make sure that you have any documentation prepared for the judge. The appeals board states that if you're scheduled to appear in person, bring any papers that support your case. These should include any important information such as letters, doctor's notes, pay records. Bring 3 copies if you can. The judge will keep a copy of the papers as evidence in the case file. If you're scheduled to appear by phone, there is a deadline for sending your papers to the judge before the hearing. This deadline is going to be listed on your notice of hearing. So what if you need an interpreter? The notice of hearing will let you know if an interpreter will be provided. If it does not provide one, then call the Office of Appeals right away at the phone number listed on your notice of hearing to request an interpreter. For those of you who have recently moved, call the Office of Appeals right away by the phone number listed on your notice of hearing. Claimants must also contact EDD by completing the change of address portion of the continued claims form or by going to edd.ca.gov. Once your hearing has been held, then the judge will issue a decision. If you agree with the decision, then that will be the end of the California Unemployment Insurance Appeals Board process. However, once the decision is handed back over to the EDD, unfortunately, there is no specific time frame for applying the decision, and this can take several months. If you miss the hearing, you may, in writing, request a reopening of the case and request a new hearing. Your letter requesting the reopening of the case must explain why you did not appear for your hearing. Reopening will be allowed only if a judge decides that you had good reason for not appearing to your hearing. If the judge did not rule in your favor and you disagree with the judge's decision, then next you can file an appeal with the field office within 30 days. The field office will forward the appeal and case information on to the board for review. The board will then review the judge's decision and the board will issue a decision. Now, if you disagree with the board's decision, then you have 6 months afterwards to appeal that decision. In order to appeal that decision, you would need to contact your county superior court and file a petition for writ of mandate with that court. Now, I cannot provide you a specific form or location to contact. What you would look up would be your county superior court, and then once you locate your county superior court's information, you would look up the process for filing a petition for writ of mandate. Okay, you guys, I hope that was helpful. Let me know in the comments down below, for those of you who are appealing, what has your experience been? What point in the process are you in? And have you chosen to bring in legal representation, or are you handling the appeal on your own?